Justice Varma cash controversy has rocked the higher judiciary. Chief Justice of India has launched an inquiry. Police is also investigating the matter. The video of burned note bundles too were put in public domain. Now, the issue is of transparency and probity. Can judiciary restore public confidence? And most importantly, is it the right time to rethink NJAC Act that was struck down by the Supreme Court in the name of judicial independence? On this issue, I'm joined by former Law Minister Ashwani Kumar. Thank you so much, sir, for joining me. And let me begin this conversation by asking you, what is your opinion on Justice Varma's case, sir?
Well, it is a very unfortunate development in the history of India's judiciary. I don't think in recent memory any recovery of this kind of money has been found from the house of any judge. It is worrisome, it is troublesome, it has naturally given rise to an outrage. And I hope that the process of inquiry that Honorable the Chief Justice of India has initiated will lead to unraveling of the truth. But having said that, I do want to make a point, which is that justice to anyone should not only be done, but should be seen to be done. Over the last 4 or 5 days, the kind of trial by media of Justice Ashwani Kumar that we are all seeing is also worrisome. After all, here is a person who has denied that the money belongs to him. It may be true, it may not be true. But somebody has to come to a definitive finding that the money recovered from an outhouse of the judge was relatable to a judicial misconduct on the part of the judge. I hope that one way or the other, the inquiry committee constituted by Honorable the Chief Justice will be able to arrive at some conclusion. If it is indeed established that this money is unaccounted and relatable to the misdemeanor of a judge, then I think it is the end of the road for the Honorable Judge, because that is how the removal procedure of the judge is. In which case, the Chief Justice will have to ask him to either resign. Of course, the work allocation to him has already been stopped. And if he does not resign, the Chief Justice may even ask Parliament to consider an impeachment motion. Now, so far in the history of this country, there were 2 impeachment motions of Veeraswamy and Justice Soumitra Sen, but they were not carried to the logical conclusion. I sincerely hope that in case, I'm making this caveat, because I think you have to be fair to the judge also, in case it is found by at least a preponderance of credible evidence that the money recovered is relatable to judicial misconduct, the judge has no option but to go. And that is how it should be.
So how does one restore public confidence?
You know, public confidence certainly needs to be restored in the judiciary. And it is not Justice Ashwani Kumar's case which has raised question marks about the judiciary. The people who practice in courts of law know that some of these so-called elevated judges, people don't speak very well about them as well. There has been disquiet about the goings-on in the judiciary for quite a while. This is not the first time it has happened, but now this is the most brazen kind of a recovery of money that has ever been seen in a judge's house. So therefore, it has naturally led to several questions, and also the question about whether the process of the appointment of the judges should be changed. And that is why the NJAC issue is now again at the center of the controversy.
So this is the moot point of my conversation with you. Do you think it is the time to rethink NJAC? And what are the redeeming features of NJAC? If you can just take us through.
You know, Karthikeya, the evolution of constitutions is a function of the evolution of society. And as the famous political philosopher Harold Lasky said, ideas must wait upon events that give them birth. This is an event that will rebirth the debate around possibly a better mechanism for appointment of the judges. Now, the NJAC was brought for consideration of the parliament and was passed by an overwhelming supermajority, cutting across the political lines. All parties supported that move. It said that the appointment commission would consist of three senior most judges, as is the case now, but it will also have the law minister and two eminent persons. Now, to say that such a committee would necessarily erode the independence of the judiciary is, I think, stretching the argument too far. The constitutional bench that declared the NJAC as unconstitutional and ultra vires the basic structure of the constitution also had a dissenting opinion of Justice Charameshwar. And I've written it in one of my articles that I, for one, find Justice Charameshwar's argument more convincing. To say that independence of the judiciary is a part of the basic structure of the Constitution is a correct proposition. Nobody can dispute that. Independence of the judiciary ought to be a part of the basic structure of the Constitution. However, to equate independence of the judiciary to the manner of appointment of judges is a flawed extension of that argument. There is no guarantee that judges, when they appoint their colleagues as judges, will necessarily choose the best people, as has been demonstrated time and again, and this particular case is a case in point. And please remember, till the judges' cases, 1991 and first, second, third judges' cases were decided, and by a process of interpretation, the Supreme Court said that the word consultation would mean concurrence. The fact remains that some of the finest judges in history, till date, were appointed when the government was the sole appointing authority. Please do not forget that.
So basically you're saying that when it comes to appointment, you require transparency. When it comes to functioning, you require autonomy, and those are two different things.
Well, of course, in the functioning, there has to be autonomy. Nobody can interfere with the judge's judicial function. But as far as the appointment of judges is concerned, to say that the elected government of the day, speaking through the law minister, will have no say in the appointment is incongruous to democracy. How can an elected government, having the mandate of the people, be denied a role in appointing judges to the higher judiciary? And Justice Charameshwar, if my memory serves me right, had quoted somebody and said something with great felicity. He said, for how long will people have faith in the judges who have lost faith in the people's representatives?
Sir,
have you been able to get it? It's
yes.
a very profound statement. You know, the people are entitled to tell the judges that if you have no faith in our elected representatives, we have no faith in you. And that would be a disastrous consequence for the separation of powers. For this, I was quite surprised that the Supreme Court in its wisdom struck down the NJAC that had the support of almost every single member of parliament who was called upon to vote on that motion, which therefore means that a few judges in black robes sitting in the Supreme Court can undo the will of the people. That was never the idea of judicial review in a constitutional democracy. Judicial review was meant essentially for the protection of fundamental rights of the people. Through processes of interpretation, you can keep on enlarging one branch's remit and keep on diminishing the other branch's remit. That is not, in my view, the right way to run a constitutional democracy.
So you're saying that an idea that was conceived when UPA was in power, you were law minister in the second tenure of the UPA, an idea whose time has come now?
Yes. In fact, I must tell you, I had the largest possible political consultations with members of the opposition, including with the late Mr. Arun Jaitley. And everybody agreed with this proposal. Everyone. At a time when the UPA government was seized, was under siege by the entire opposition, this was one motion on which there was unanimity. And this has now been set aside by the Supreme Court. So clearly, NJAC or something similar to that is an idea whose time has come.
So
and we must,
in terms of legislative politics, if Supreme Court says that this violates basic structure of the constitution, and Parliament holds the supreme authority in context of the way a constitution is interpreted. Can you tell us the route if NJSC has to be rethought, reimagined, repurposed? What is the legislative route, sir? What is the power route that we need to take?
Let me clarify. The final authority about interpreting the Constitution is with the judiciary, and that is how it should be. Parliament does not perform a judicial function. Parliament performs a legislative function, a sovereign function to express the will of the sovereign people. Who is sovereign in a system of democracy? It is the people of India who are sovereign. And that sovereign power of the people is divided through the constitutional mechanism into three branches of government. The unbroken constitutional power, unbroken sovereign power of the people is broken into a judicial power, executive power, and legislative power. Each branch of government has to perform its functions, which are now well delineated and well settled. Parliament does not exercise a judicial function, and the Supreme Court does not exercise a legislative function. But what is happening now, under the garb of interpretation, the Supreme Court is becoming a judge in its own cause. The NJAC was concerned with the appointment of judges, and a group of judges decided to say, no, hands off, we are the only people who will decide. Nowhere in the world, hardly maybe one or two countries, I can't recall now, but I remember we had done a full research. Nowhere in the world do the judges have absolute power of appointing judges.
So the bill will have to go through the Parliament again?
Of course, no, of course, that bill has been struck down. So it will have to be reworked if indeed there is political consensus, and that is a prerequisite. If there is a political consensus that we want to revisit the appointments processes as far as the High Judiciary is concerned, either something on the lines of NJAC or something better will have to be thought out, and it will have to go to the Parliament. And the legislative branch will make a law and will propose for which constitutional amendment would be required. So therefore, the government of the day will have to marshal the requisite majority for passing the constitutional amendment. And I think, I have a feeling that we are moving in that direction.
People do understand that there was a time when politicians started talking about committed judiciary. That is why they say, well, keep the judiciary, independent, don't interfere with it. There was a time in 70s when this concept came, and there is a public understanding of it that judiciary needs to be independent.
No, quite clearly, I am all for a judiciary that is entirely independent. But that independence is not ensured only by judges appointing their own fellow brothers. On the contrary, so many question marks are raised by these appointments. Every day, these questions are being raised. That there is a kind of a judicial oligarchy which is deciding on who is to be appointed and who is not to be appointed. It is not that these questions are not raised, and these trouble the judges also. For example, let's say an outstanding lawyer who is the son of a very senior judge will now have to face much greater scrutiny before he's appointed, because questions have been raised that judges are appointing their own people, which is also unfair. Why should an outstanding lawyer be denied the right to be a judge merely because he's the son of so-and-so? At the same time, it is equally true that sometimes the best people, most knowledgeable, with unblemished record of integrity, are overlooked and are not made judges. It happens. So I think we need to take this matter to its logical conclusion and ensure that that a very important pillar of India's democracy remains above reproach. I am one of the lawyers who spent in the old tradition where Supreme Court judge was regarded as God and the High Court judge was regarded as demigod. We could never even imagine something wrong about them, leave aside being rude or discourteous about them. But now I see fingers being raised on a daily basis, which is unfortunate.
Thank you, sir. Thank you so much for joining On Point. And I think that's the moot point which Ashwani Kumar, former Law Minister, has made, that the time of the idea which is NJAC, that was birthed during the time of UPA 2, has come. And he thinks that, again, the route of consultation, legislation will have to be undertaken by the parliamentarians.